because there is hope, and we are lucky today. We have the policymakers with us. We have the big guys with muscles, and I feel very lucky, in particular because I have two representatives of the European Commission for the price of one. So I'm very happy. Irene will start the discussion and will discuss our work, okay, and obviously the digital single market strategy, our hopes and ambitions, let's put it this way. And then Helge will follow, focusing more on the IP enforcement side of the debate. And actually that's a good combination because I suppose you all remember that the e-commerce directive was adopted in reaction to the US DMCA, which is very much a copyright act. Okay, so if the e-commerce directive is not working in the field of copyright, then we have problems. And then we will have from Pascal or Sky, so I hope it will work, and then our panel. Okay, so you've got the mic.
Well, thank you very much for these nice words, and hello everybody. I would like to start saying that I'm here talking in my personal capacity. If I say I'm going to regulate platforms, don't tweet saying the Commission is going to regulate platforms. Or if I say I'm going to kill anybody, don't say the Commission is going to kill somebody. This is just me. Just a policy officer. For us, it's very useful to have these discussions with you, with researchers, with the academia, because we usually have stakeholders calling at our door on a daily basis, but we don't usually have these constructive discussions with the researchers. We spend a lot of time discussing and trying to analyze and understand what we have written in some pieces of legislation or in communications, which I admit sometimes is very difficult to understand. But I would like to see you in my shoes, because you don't need to please everybody. We need to please intermediaries, we need to please the right holders, we need to please all enforcement authorities and all kind of notice providers. We have to please the civil society, the users, or hierarchy. It's, it's not an easy work. I would like to start, you all know the e-commerce directive by heart, you know the liability regime, the articles 12 to 15, so I'm not going to extend myself in this. The only thing that we need to keep in mind is that the purpose of the e-commerce directive and the liability regime was to establish a system which should be technologically neutral and balanced and future-proof. The fact that it's been 15 years ago that the directive was adopted, and it's still applied. Some would say it doesn't work, some would say it's still valid. The fact that it's still there, it's for me a reason to say that this has been managed. Second point is that it is a horizontal directive. Unlike the American system, we apply the liability regime to all kinds of illegal content. We don't have a specific rules for copyright and other rules for other kinds of illegal content. And this is something that we always have to keep in mind, even if whenever we talk about the liability regime, we immediately think about copyright and right holders and all these things. And the third point is that the liability regime talks about activities, not about actors. It's not relevant who is the hosting service provider. What is relevant is what is a hosting service. And in this sense, we have been discussing a lot whether the new business models that have appeared in the market are hosting, are caching, are mere conduits. But this is the reason why, for example, there is no definition of intermediaries in the directive. Because an intermediary is anybody who acts as hosting, as caching, or as a conduit. And basta. This is just to show plurality of kinds of illegal content that we deal with. And this is just a small example. And the other element that I would like to stress from the liability regime is Article 15. We have been hearing about it these 2 days, whether it's still fit for purpose, but whether it's really valid. Do we have now injunctions that go much far beyond what Article 15 says? We are encouraging intermediaries to take actions which actually go against Article 15, but as we are not obliging them to do it, it's not a problem. And we have arrived to the moment where the new Commission came in force last year, and somehow they did a kind of tabula rasa with the work that had been done before. And in the particular field of the liability regime, it was included under the more the wider elements of the comprehensive assessment of platforms. Whether this was wise or not, it's not for me to answer. But the truth is that we have a problem in identifying platforms and intermediaries, because it's simply not the same. There are platforms which are not intermediaries, actually only a few of them, and in any case there are intermediaries which are not platforms. If we are treating everything together, it's mostly for political reasons that I'm not going to tell you. But you don't need to try to think what is the legal rationale behind. There's no such thing. But in any case, what we know, what is written in the DSM communication, is that the Commission commits itself to start a comprehensive assessment before the end of 2015. Well, I'll tell you, this comprehensive assessment has started. We are working constantly on trying to assess it, but the good thing is that we don't have a deadline. We know when we have to start, but we don't know when we will finish. So we will have some time to analyze and to assess comprehensively the role of platforms and intermediaries, and in particular, as point 5 says, how to best tackle illegal content on the internet. In particular, as regards the intermediary liability, the Commission commits itself to analyze the need for new measures to tackle illegal content in the internet, which is a bit surprising, if I may say, because in 2012 there was a communication where the Commission already announced that it would take an initiative on notice and action. It was the same Commission, but it was not the same Commission. So we start again, and we start analyzing again whether it's really necessary, and if yes, how. What do we want to do? We want to establish a procedure for removing illegal content, a notice and action system, a harmonized system to notice illegal content. How are we going to ensure that we protect the fundamental rights of freedom of expression and information by doing it? And finally, which is something new, this is a new element that it's included in the DSM strategy, whether we can ask intermediaries to do more. And this is what has been called this duty of care. The truth is that the intermediaries are mentioned in the DSM strategy in 2 different positions. One is here under the main issue of platforms, but the second is under the copyright, and my colleague Helge will give us more information on that. The difference is that they have a deadline, so they have a problem. And maybe they will take some measures that will have an impact in our comprehensive assessment. So you can imagine that there are 2 different departments having some kind of race in who does what before. To know what we want to do, we need to see what we have done before and where do we come from. You are well aware of the antecedents of the liability regime and the discussions that the Commission undertook. I will go very quickly through this. In 2010 there was a consultation on the e-commerce directive, 10 years after its adoption. The question was, is it still fit for purpose? Does it work? It is clear, and after getting 420 replies, the main idea that the Commission got is fit for purpose, don't touch it, because if you touch it, it could be worse. But please, if possible, clarify some elements of the liability regime, because we don't know what's hosting, we don't know what is expeditiously, we don't know how to implement this notice and action system which is not established in the directive, etc. So, in 2012, as a consequence of it, the Commission, as I said, announced the idea of tabling an initiative on notice and action, and again consulted the stakeholders on notice and action. And in this case, we got 1,060 replies, which is quite a good number, even though afterwards you have to read them, but this is the second story. And the main results that I would like to highlight very quickly are the following. First, almost or more than half of the respondents said that action against illegal content is often ineffective and lacks transparency. And 64% said that a lot of action is taken against legal content. They needed more clarifications on the concepts of hosting and actual knowledge and awareness. And they needed to describe the alleged illegal nature of the content. This is quite logical. Some of them, or 77% said that the notice, the sender of the notice should be identified, which can be a problem, for example, as regards child pornography. Because our colleagues working on child pornography said, you cannot ask the notice provider to identify itself because what he's doing is illegal. This poses a challenge when establishing a horizontal approach to this question. 71% said that we needed a counter-notice system. 80% said that we should avoid unjustified or bogus notices. And this comes again in discussion when we talk about roll notices. And 72% said that different kinds of legal content needed to be treated differently. Where do we stand now? Now the DSM strategy has been published, and the public consultation on platforms, including liability issues, will be published very soon. In any case, you have read it already because it was leaked. There are no surprises. This was not the final version, so maybe you will get some surprise, but still. The next step will be during the 12 weeks that the consultation will be in place. We will organize targeted consultations and roundtables with Vice President and workshops on the issue of liability. And we will be conducting studies to collect evidence. And in this particular issue, I would like to call you for your help first in participating in the consultation, because if you really consider that there is something which doesn't work, tell us. Give us evidence. If you are aware of studies which demonstrate that some policy options are not really valid, we will need to hear about it. What are the main issues that we will concentrate on the consultation? First, again the question, is the e-commerce directive fit for purpose? If you don't believe it is, then tell us. What is hosting? And in this particular issue, we have quite a lot of interesting ideas from our colleagues from the copyright, because in their opinion, those hosting providers who are very actively involved in the content distribution shouldn't be considered intermediaries. And in this sense, we have been discussing about national decisions from courts, also from the ECJ, but still the idea is there, and we need to treat it because it's really an issue. The intermediaries in 2015 don't do the same kind of work that they did in 2000. So do we need to change the interpretation of hosting? On the notice and action, we need to see whether it is possible to to continue with the horizontal approach, which is in the e-commerce directive, one size fits all. This is what we try to get the information. And what should be the legal requirements of a notice. The counter notice procedure, what would be the safeguards against false notices. These kind of things need to be clarified. And finally, the duty of care. I will talk later about that. I will go very quickly. There are some examples. The member states are legislating because the Commission doesn't do anything. We do it ourselves. We have several decisions of national courts. In this case was GEMA against YouTube, and the German court said that YouTube is a hosting provider, and as such is covered by Article 14. And what can we say about the duty of care? Or what we understand under duty of care, because it's not the same that other people understand under duty of care. We know that there is a gap between what the intermediaries are obliged to do and what they actually do, or at least the big ones, those who have the resources to do it. We know that they are taking voluntary measures to tackle illegal content. We know that they are invited, encouraged, forced to take this kind of measures by national authorities. There are agreements, and we need to have a complete overview of this. And we need to know what is the cost compliance of these measures, because what Google does is not necessarily possible to be done by anybody, by any intermediary. Can we ask everybody to do what Google does? Is this the benchmark? There are several examples. You know very well, France had an agreement with the big ones to fight against terrorism. There have been some agreements between the government and the intermediaries to tackle illegal content as regards copyright, for example in Denmark. This is in English. And the last one I am aware of is in Portugal. They also have a memorandum of understanding to fight against copyright infringements. And that's all, but in any case, this is not me who's giving you the answers. I'm giving you the questions. And I need to get the answers from everybody, and in any case, the decision will not be taken by me, unfortunately. But I would like to summarize some open questions that I take with me in my luggage tonight. First, can we ask, we, European Union or the member states, can we ask intermediaries to take measures who could be potentially limiting fundamental rights? Can we encourage co-regulation in this field? Because the European Union compromised itself not to limit fundamental rights through co-regulation. If the limitation to fundamental rights has to be necessarily done by law, can we increase the legal obligation of intermediaries in this sense? Or should we be very careful with the fair balance that has been done through the liability regime in the e-commerce directive? Or is it better for everybody to have clear rules, legal obligations? Because if we talk about moral obligations, for me, maybe common law is different, but for me a moral obligation is not enforceable. And if it's not enforceable, it's not an obligation. So it's very difficult. Because, also the last question, if we ask intermediaries to take voluntary measures, and through these voluntary measures they get actual knowledge, can we be so mean and then impose liability because they have taken these measures we have asked them to do? It's quite a dilemma, and I don't think we will be able to please everybody, but we will try. Thank you very much.